Hello, my name is Brian York. This is a case study for Week 6 of EDU 503 Sports Law for William Wood University. The case I am going over today is Marianne Stanley versus the University of Southern California. The basic facts of the case: Marianne Stanley has sued the University of Southern California, or USC, and Michael Garrett, the USC athletic director, for gender discrimination and breach of employment contract. She lost in a summary judgment in favor of USC and Mr. Garrett and is now appealing. To understand the timeline of this case, it really is important to understand the events leading up to the case. Marianne Stanley was hired as the University of Southern California women's basketball coach in July of 1989. It was a 4-year contract starting with a base salary of $60,000 and increasing to $62,000 by the final year. On April 20th of 1993, a few months before her contract was to expire, Stanley met with Michael Garrett, then USC athletic director, to negotiate her new contract. No one denies this meeting, but there is a disagreement as to what was said in the meeting. Stanley says she agreed to a contract equal to George Raveling, the USC men's basketball coach. Garrett states that USC would not be able to pay that salary, and that he said that several times throughout the meeting. This becomes crucial because in her case, she insists that they have a contract based on this conversation. On April 27th, Garrett raised his offer and put it in writing to Stanley to offer a contract over 3 years, $80,000 in year 1, $90,000 in year 2, $100,000 in year 3, plus $6,000 per year for housing. Stanley rejected this offer, saying she wanted to be paid the same as Raveling, based on gender rights and equal pay for the same job. He said that this is not the same offer from April 20th, so she was not going to accept it. On June 7th, Stanley proposed a 3-year contract at $96,000 per year, then equivalent to Raveling for the remainder of her term. Garrett rejected that. On June 18th, Marianne Stanley contacted her attorney, and the attorney proposed to Garrett a 3-year contract with an automatic 2-year renewal. First year was $88,000, second year was $97,000, third year was $112,000. Again, now Ms. Stanley's bringing in her attorney as opposed to working one-on-one with the athletic director, and Garrett rejected that offer and then withdrew the only written offer from the April 27th. On June 21st, Mr. Garrett sent the attorney a written offer for a 1-year contract, good for $96,000. So again, now USC and Michael Garrett have pulled back and gone from a multi-year contract to a single-year contract. On June 30th, Marianne Stanley's contract expires, but she continues to do her duties such as recruitment and such. July 13th, Ms. Stanley asked Mr. Garrett for a multi-year contract. He refused. He said his offer from June 21st will expire at the end of the day on July 13th. On July 14th, she asked him for more time to consider the contract. On July 15th, Mr. Garrett revoked the offer and told Stanley that USC would be seeking a new coach going forward. On August 5th, Ms. Stanley and her lawyer initiate the court case in Los Angeles County Superior Court on claims of sexual discrimination and retaliatory firing. On August 6th, the court grants a temporary restraining order granting Stanley's request for reinstatement as her coach at a salary of $96,000 per year. On August 6th, the defendants moved the case to a federal court because this is under federal law as part of the civil rights laws and Title IX. On August 30th, district court denied the preliminary injunction, and again, Stanley appealed. January 6th, 1994, this denial was upheld, and then from September 1993 to February of 1994, Ms. Stanley amended several of her claims, and the defendant's motions to dismiss were all granted. Ms. Stanley's arguments were many. First, violation of the Equal Pay Act and the California Fair Employment and Housing Act. Violation of Article 1 of the California Constitution. Violation of Title 9 of the Civil Rights Act. Retaliatory dismissal. Wrongful discharge in violation of public policy. Breach of express contract. Breach of implied in fact contract. Breach of implied covenant and good faith and fair dealing. Ms. Stanley sought back pay, as well as $3 million in compensatory damages and $5 million in punitive damages. Now, the courts basically threw out all but the Equal Pay and Title IX Civil Rights Act arguments because she was not fired, her contract expired, and the university and Mr. Garrett had lots of documentation of good faith negotiation that just did not come to an agreement. So we're just going to move on to the defendant's arguments again, because basically the only thing really at question here is the Equal Pay Act and Title IX. So on October 17th, 1994, they filed for summary judgment, and it was granted on March 10th, 1995. The Equal Pay Act puts the burden on the plaintiff, so Ms. Stanley, to show that other employees of the opposite sex were paid a different wage for essentially equal work. Stanley claims the differences between the two jobs is just because of the disparate treatment of the two programs by the university. In other words, there's your Title IX violation, saying that the university treats the men's program differently than the women's program, and that is why the jobs are not equal. USC argues that the differences are due to revenue. The differences are due to spectator and media market, not anything the USC has done currently or in the past. So again, in the law case, nothing I did before, nothing I've done now, nothing I'm doing in the future is wrong. And again, you can see that they won that case as well. Excuse me. The defendant's arguments. The EEOC, Equal Employment Opportunity Commission, can allow for USC to show that difference in pay is due to the experience and expertise or any factor other than sex or gender. Mr. Raveling, the men's coach, began coaching at USC after 31 years of coaching experience. Stanley began after 17 years of experience. Raveling had twice been named National Coach of the Year and twice named Pac-10 Coach of the Year, their conference Coach of the Year. Stanley had no such awards. Raveling coached the U.S. Olympic team. Stanley had not. Raveling had 9 years of marketing and promotional experience and had published several books both on marketing as well as basketball. Stanley had no publications to her name. The EEOC affirmed that the pay differences were because of Raveling's experience and expertise rather than gender. So the judgments. The appellate court upheld all of the defendant's summary judgment on the Equal Pay Act. They decided that Stanley had no legal contract from the April 20th meeting because, again, that's that first meeting where Stanley said that Garrett agreed to give her the same pay as Raveling, but there was no contract, therefore there is no breach of contract. After negotiations that were documented by Garrett and USC, she cannot claim that USC acted in bad faith with respect to contract negotiation. She was offered a 60% raise at one point. Again, they did offer $90,000 a year when she was at $60,000 or $62,000 in her final year of her current contract. Final judgment upon appeals was that the original summary judgment in favor of the defendants was the proper one. The implications. First and foremost, document everything. This is true not only with coaches, but with students and parents and suppliers. Everything needs to be remembered properly. Don't throw away any emails. Take notes on every verbal conversation. That way you have proof of everything that was said and done. In terms of Title IX, evaluate every aspect of a program for gender equity. Not only coaches' pay, but practice times, practice locations, game days and times, Locker room quality and access. Access to facilities. Access to trainers and other medical professionals. Access to uniforms and quality of uniforms and equipment and quality of equipment and the quality and skill of coaches. Make sure that everyone has as equal a shot as everyone else. Thank you and have a nice day.